Good morning, everyone. I'm Rudraksh Vishwakarma, an intern at Law Minds. Today, I'm presenting on legal challenges in cybersecurity for government agencies. So, let's start with an introduction. Today, in our digital world, cybersecurity is like a strong shield protecting important data from sneaky cyber attacks. But for government agencies, it's just not about using the right tech tools. They also face tricky legal problems that they must solve. Let's come to a scenario where government agencies who have important job of keeping our country safe are under attack by clever hackers trying to break into their computer systems. But stop but stopping these attacks isn't just about using antivirus software. It's also about understanding complicated legal rules. At the center of this challenge is the duty of government agencies to keep their own secrets safe while also protecting the private information of citizens and businesses. This means they have to be really careful about how they handle data and be honest about what they are doing. After all, people trust these agencies to keep their information safe and respect their rights. Balancing need for strong security with the right of individual stuff. It means understanding the rules, knowing what threats are out there, and making sure everyone's rights are respected. For for government agencies, this means coming up with plans to stop bad guys, to stop to stop bad guys while but still following the law and being fair. Now coming to the legal framework and compliance. One of the primary challenges in cybersecurity involves compliance with various laws and regulations. These laws can range from General Data Protection Regulation 2018, aka GDPR, in the European Union, to Health Insurance Profitability and Accounting Act 1996, HIPAA, in the United States of America. In India, the legal framework for cybersecurity is primarily governed by Information Technology Act 2000. This act was established to provide legal recognition for transactions carried out by the means of electronic digital interchange and other means of electronic communication. This act establishes a legal framework for e-governance by recognizing electronic records and digital signatures. It also characterizes cybercrimes and stipulates penalties for them. The act led to creation of control of certifying authorities to oversee the insurance of digital signatures. It also sets up a cyber appellate tribunal to adjudicate disputes arising from this new law. Furthermore, the act amended various sections of IPC, the Indian Evidence Act, the Bankers Book Evidence, and the RBI Act of 1934 to make them compatible with the new technologies. While Information Technology Act offers solid legal framework, it's crucial to remember that cybersecurity is a swiftly changing field. Consequently, the legal landscape must constantly evolve to keep up with the technological process. Now coming up to the next topic, privacy concerns. One of significant challenges is balancing security needs with privacy rights. Government agencies often handle personal data, and any security measures must respect the privacy rights of individuals. This is particularly challenging given the global nature of the internet and differing privacy laws in different jurisdictions. Global privacy laws include globally several pivotal privacy law over cybersecurity. For example, the GDPR of the European Union has significantly influenced how organizations around the world manage personal data. Uh, it introduces new data protection rights for individuals, strengthens the obligatory data protection requirements, and imposes considerable legal duties on entities handling personal data. In the United States, legislations like the California Consumer Privacy Act (CCPA) ensure responsible handling of personal data and provide legal remedies if the data is mishandled or misused. Now coming to privacy laws in India. In India, the Information Technology Act of 2000 is the main law dealing with cybercrime and e-commerce. This act provides a legal structure for e-governance by recognizing electronic records and digital signatures, and it also characterizes cybercrimes and prescribes penalties for them. Recently, India enacted a Digital Personal Data Protection Act 2023. This sets guidelines for how organizations should manage personal data and give citizens control over their personal data collected. Now coming to our next topic, liability issues. Determining liability in the event of a data breach can indeed be a complex process. This complexity arises from questions about whether the responsibility for the breach lies with the government agencies or a third-party service provider. Additionally, victims of the breach may seek compensation, potentially leading to legal disputes. In India, the Information Technology Act is the main law that deals with cybercrimes and e-commerce. Under Section 43A of the IT Act, a corporate body handling sensitive personal data may be held liable to pay damages to the person affected if they are negligent in implementing and managing reasonable security practices. In the case Puttaswamy versus Union of India 2017, with citation 2017-10 SCC 1 or 2017 SCC Online SC 996, the Supreme Court of India unanimously held that privacy is a constitutionally protected right. The court held that the right to privacy is an instant part of the right to life and personal liberty under Article 21 and as a part of freedom guaranteed by Part 3 of the Constitution. The court also held that the claim of protection of privacy can be against both state and non-state actors, as the danger in the age of technological development can originate not only in the state but from non-state entities as well. In the context of data breaches, this ruling implies that if a breach occurs due to negligence of a government agency in implementing and managing reasonable security practices, the agency could potentially be held liable for violating the constitutional right to privacy. This could lead to legal battles where victims of breach seek compensation for the violation of the right to privacy. In a recent case of W. M. Morrison Supermarkets plc versus various claimants 2020, Visagation 2020, UK SC 12, where distinguished Morrison employee posted the personal data of nearly 100,000 Morrison employees online. The employees initiated a class action against the company, seeking damages for breach of the UK Data Protection Act, misuse of private information, and breach of confidence. The trial judge ruled that the company was not directly liable to breach of the statute or at common law. However, the courts held Morrison to be vicariously liable for the actions of his Russian employees because the laws of this is sufficiently connected to the legitimate employee duties, employment duties. But the Supreme Court of the United Kingdom overturned this ruling that Morrison was not vicariously liable. The court found that the employer was not acting within the scope of his employment when he committed the wrongdoing. Wrongdoing. Instead, he was posting a personal vendetta against the company. This case highlights the complexities involved in attributing responsibility in the event of data breach. It, dem- it demonstrates it demonstrates that while an employer can be held accountable for the actions of his employees, this accountability is not unconditional and hinges on the specific circumstances of each case, the intent of the employees, and whether they were acting within the boundaries of their employment are crucial factors that courts take into account. This case also emphasizes the significance of strong data protection strategies and policies to avoid such breaches from happening in the first place. Now coming to our next topic, which is international cooperation. Cybersecurity threats often originate from overseas, requiring international cooperation for their resolution. However, this cooperation can be hindered by contradiction, uh, various legal systems, extradition laws, and diplomatic considerations. The United Nations has taken a leading role in fostering international collaboration in cybersecurity. The International Telecommunications Union (ITU), a UN subsidiary, initiated the Global Cybersecurity Agenda, a strategy for global cooperation designed to bolster trust and security in the digital society. Various forms of international cooperation exist, such as worldwide collaboration under the umbrella of international organizations like the UN, regional collaborations through entities like the European Union and NATO, and cooperations on a bilateral basis. Various forms of international cooperation exist, such as worldwide collaboration under the umbrella of international organizations like the UN, regional collaboration through entities like the European Union and NATO, and cooperation cooperation on a bilateral. However, these efforts can be implemented by differences in legal system regarding extradition and diplomatic factors. There is an immediate need for states to collaborate in order to counter threats like cybercrime, attacks on critical infrastructure, electronic espionage, mass data interception, and aggressive operations armed at exerting power through a cyberspace. So now, concluding this topic, uh, I see that in conclusion, while the significance of cyber While the significance of technology in cybersecurity is a plan is a play is a play to crucial role, it's evident that legal aspects hold equal importance. Government bodies are required to steer through a complicated network of laws, rules, and international factors in the pursuit of cybersecurity. In doing so, they not only safeguard their systems and data but also maintain the rights and trust of the citizens which they are committed to serve. Thank you.